listens.
Never did. I don't know if the judge. Any question? I'm not sure where that is. I don't have it in this folder. They got to get back there.
All rise. Honorable Wade Joker, Patrick III, Judge of the Circuit Court of Raleigh County, now sitting. You may be seated. Good morning.
Morning, Your Honor.
Court calls the case, State of West Virginia versus Natalie P. Cochran. This is case number 23-F-343K. The record should reflect that the state appears by Tom Truman and Ashley Acord, assistant prosecuting attorneys. The record should further reflect the presence of the defendant, Natalie Cochran. She is represented by defense counsel Matthew Victor and Stanley I. Selden. We are here to conduct a pretrial hearing or conference in this matter. Also, we have several motions to take up. The first one of importance is the defendant's motion for dismissal of case or continuance of trial. I reviewed that motion as well as the state's response. Do you have argument to present, Mr. Victor?
Your Honor, I think I have outlined everything in my motion there was to be outlined. I have received today what I can only describe as technological gizmos that contain what the state purports to contain. I have to obviously review that. I have no idea what I will encounter there. But if we're talking about a trial that is realistically going to be set for the 21st or the 22nd with the jury selection, then it's unrealistic to believe that all these tasks that we have ahead of us can be accomplished. Either we get all the discovery or we don't. And I'm not blaming individual prosecutors. I'm not blaming that office. What I'm trying to tell this court is that right now, after several months of asking for the documents and or the record that we believe to be indispensable in this case and absolutely crucial for the defense of this case, we are looking at incomplete discovery, and we're looking at less than 2 weeks before the trial realistically begins. So that cannot be accomplished, it cannot be done. Since the state failed to provide us with the entire discovery in this case, I file a motion to dismiss. Perhaps more realistic is the postponement of this case until the whole process of the discovery is complete, and that will require still a lot of things. It will require, for example, the phones that one we know that cannot be opened by diffusion. We will never ever learn, if we proceed to trial in October, what was on the phone of the alleged victim. We suspect that's his. Well, we know it's his phone. It's encoded, so that needs to be decoded, and we need to find out what's on it. We have received the documentation concerning the alleged bottle of insulin that was seized from the defendant's house, the defendant's refrigerator. The state claims that, for whatever it's worth, that the bottle of insulin was punctured, and provided us, and this is the most recent, with probably, I don't know how many pages, I didn't count them, but voluminous records from the FBI dealing with the issue of the bottle being punctured and perhaps breached, or whatever you want to call it. For what purpose, I don't know, but it obviously is not a good purpose for the defense. So now we need to not only review that, but we also have to subject this discovery to some critical review by our expert, because we don't believe that this bottle was ever punctured from the pictures that we had recently obtained. That will take time. We have received flash drives, we have received the evidence from apparently the search of the defendant's home. We already know that it's incomplete, that there's at least a phone there that hadn't been opened, and so we don't know what that evidence might be, and we believe that there is exculpatory, or at least impeaching information on that.
You're talking about
Diffusion.
Mr. Cochran's phone.
Right. Now, I have to tell the court that, as I mentioned in my motion, we had received another phone from the defendant's family that we believe is also the phone of the late Mr. Cochran. We also have to open it. It's also encoded. Now, that had nothing to do, of course, with the state, but that item has been provided to us most recently again. That needs to be decoded. We need to figure out what's on it. Then we have received several prior flash drives that nobody could open, including our offices, and for that matter, the prosecutor's office got stymied in the middle of the opening that flash drive. I don't know if what we have now is the same flash drive that we had received before that nobody could open. We had previously received not yet another flash drive that contained the information that was the same as the very first original flash drive provided by the prosecuting attorney in the previous case, the 447 number case. So as of now, I have no idea whether we have everything that has been collected by the state, that has been seized by the state, photographed, recorded, decoded, or whatnot, because we have just received that. And I have received it today. I believe Mr. Selden received that on Friday. An issue involving the experts. I think Mr. Selden will be more knowledgeable about the status of the experts. But all I can tell the court from my standpoint is that since we don't have the complete information concerning the substances that Mr. Cochran may have ingested and the list of things that he purchased or consumed or injected, we were stymied, and we still are stymied, in presenting that evidence to our experts, so they cannot express an opinion based on the entirety of the evidence that we present to them. We can only present them with the incomplete.
All right, Mr. Selden.
And Your Honor, there one piece of discovery that has been previously requested numerous times were the disciplinary records, which I believe Your Honor requested. We have heard nothing about that. I'd like to clear up the matter of the thumb drives, if possible. On numerous occasions, we were provided with flash drives or thumb drives. Initially, a thumb drive or flash drive will be opened by anyone. Then we were provided subsequently with another thumb drive or flash drive, which Mr. Victor and I had great difficulty in attempting to open. As recently as 2 weeks ago, I believe it was, after we had a motion hearing in which we agreed to work with the prosecutor's office to see if we could clear up those thumb drives. Mr. Victor and I went over and met with Mr. Truman and Ms. Aker. The prosecutor's office couldn't even open it on one of their computers. Finally, Ms. Aker was able to open it on a second of their computers. I attempted to work with her for approximately an hour and a half to 2 hours. It took a great deal of time just to download the reader on this thumb drive. It took approximately, I'm guessing, 20 minutes to download that. And that's just to try and get into the information on the thumb drive to read it. I was in the process of attempting to do that with Ms. Aker. Quite simply, I ran out of gas. You know, after doing this for approximately 2 hours and going back and forth to speak with Mr. Truman and Ms. Aker. And I thought we left it with, we would get a third series of thumb drives that would be more readable. That was my impression in leaving. Or at the very least, we would have our expert not an expert, our investigator, come over and work with the prosecutor's office to see if we could open that second series of thumb drives. And that's the way I left it. In Mr. Truman's response, he mentions that we didn't make a sincere effort or something along those lines. We didn't avail ourselves of that opportunity. I would respectfully disagree with that. We did make an effort, and we are continuing to make an effort. Would Your Honor like me to go into my motion to compel?
No, we'll take that up shortly. I thought you were going to speak about the experts.
My motion to compel deals with the experts.
Okay, go ahead.
I filed a motion to compel to get additional information from the prosecutor's office. We don't have certified experts at this point. We have two potential experts that I have given as much information as I can glean from the discovery. That includes medical records, the two autopsy reports, and the endocrinologist's report. Any other information I've been trying to glean and feed to our potential experts as I can discover it. After speaking with one of our potential experts, he told me photographs would be very helpful. If there are any microscopic slides, that would be very helpful. I tried to go through their expert and autopsy reports to see if there were anything that might be helpful. In there was a mention of a bag of organs. I put that in. I don't really expect to get that. I would imagine that that bag of organs was reinterred with Mr. Cochran's body, and we, of course, have no intention of exhuming the body a third time. It would be an effort in futility. Now, concerning the photographs, there was mention of some photographs that were provided way back in 2019. I don't have any discernible copies of those photographs. And then in Mr. Truman's response, he says that photographs were on one of the hard drives or a thumb drive with a certificate of service, I believe, July 11th. I will go back and go into that information to see if I can reproduce those photographs, if we have been given them. But no matter what, we do not have microscopic slides that were taken in either the first or second autopsy. I'm not really sure which. That's crucial. We cannot have a forensic pathologist render an adequate report without those. And that's all I can report. As far as any other experts, I mean, we were just recently notified of two experts from the FBI dealing with the bottle. We, of course, would have to respond to that with experts of our own, and we've just been given that information, I think 2 weeks ago. I might be wrong on the date, but it was certainly very recent. We don't have any, I don't know if we have any CVs of these two latest identified experts dealing with the bottle. But in any event, that's a totally new issue. And we were handed some discovered today, I'm not really sure what it is. It's a stack of papers that we will also have to go through. I believe that concludes my comments.
All right, thank you. Let me hear from the state, please, Mr. Truman.
Thank you, Your Honor. The defendant has very little to gain and a lot to lose by this case going to trial. We know what's going to happen to her after no matter what the verdict. She's going back to federal custody. That said, and the state did not want this matter continued. The victim's family needs to have this brought to an end. That said, it is enormously frustrating to remember last Friday when the state had been telling defense counsel they had a number of items that in good faith we believe they had. It was only upon further investigation with their investigator and Ms. Acord that we discovered they didn't. That sick feeling in your stomach sunk in, called defense counsel, apologized, because I had been telling them, you got this stuff, and they didn't have this stuff. They might have had bits and pieces of it, but clearly it was not what the state thought it was. And in the back of our heads, we're saying, if they don't have that, what else is it they don't have that we thought they had? We tried to remedy that by an agreement to have their investigator come meet with Ms. Acord and go over everything on every external hard drive, every thumb drive, to make certain that they have everything. But the state in good conscience cannot stand here the way we have been and say they've got it all, because Friday proved that they didn't have it all.
Let me ask you this, do they have it all now, or can you not?
That's the problem. The court has hit the central issue. What we thought was true turned out not to be true Friday, and that is the real concern for the state, and that's why we would like their investigator to sit down with us, compare our hard drive, our external hard drives, thumb drives, etc., with what we have given them, and see if they may have everything except what we gave them Friday, or there may be other things missing too, and that is concerning to the state. We want them to have everything they're entitled to, and we in good faith thought they did, and we were wrong. And for that, we apologize to the defense and the defendant. It's a big case. It has a lot of stuff in it. And part of being human is mistakes are made. And in this case, it was a mistake. That goes to the alternative. There is no grounds for dismissal of this case whatsoever. This was a good faith error. We tried to give them everything they're entitled to, and we made a mistake, and that's on us. But there's no grounds for dismissal. There's nothing nefarious going on here. The state's not trying to hide anything. We want them to have everything. But until there's an actual comparison, we can't represent to this court that they do have everything. The discussion ended Friday, and this is Tuesday. We haven't heard from the investigator, but Ms. Acord is accommodating him whenever he's willing to appear. Judge, I am sorry. I mean, we thought this was going to go in a timely manner, and we have some concerns based upon what we discovered Friday.
Your Honor, I have to clarify one thing. In no way, shape, form, or manner am I implying that Mr. Truman or any other prosecutor in the office deliberately hid anything from us. I'm not saying that at all. I've known Mr. Truman for too long to believe that he would resort to such awful tactics. That's not going to be our argument. If mistakes were made, I can only tell the court that I believe that the mistakes may have been made, which of course necessitate the court's action here. but I cannot in good faith claim that the state has been doing anything intentional to hide the evidence from us.
Let me ask you this, Mr. Victor, how quickly could you have your investigator meet with Ms. Acord and review to see what materials you have and what materials are lacking?
We can do it today.
Is that your investigator behind you?
Yes, sir.
All right.
However, we of course we don't know the enormity of the discovery in this case may be such that it won't be, well, I'm not going to speculate, Judge, this case is huge, and it has the discovery that may or may not be reviewable in one day.
And, Your Honor, I'd just like to add to that. When I got into this case, there was over 60,000 documents to go through, and that was the tip of the iceberg. And the Fusion Center has provided these hard drives now. There's an enormous amount of information on those. The prosecutor's office repeatedly had to get larger hard drives just to download this material. I would say conservative, and the Fusion Center took over 3 weeks just to download the material. It would be virtually impossible to go through this material in a day. I would say it would be a minimum of a week just to compare what's there and what isn't there.
We're talking about a massive continuance. It wouldn't do no good to set this in December, would it?
We probably should talk with the court on that in a separate setting. Defense counsel and I have talked about that briefly, and we need to discuss some potential logistics of that. But if I could, I don't know if that answered the court's question or not. I mean, it's possible, but I don't know. I think the Fusion Center needs some serious props. They put everybody they could on this and turned it around much faster than they predicted, much faster than they thought they could. The duplicate items that were given to defense counsel today are the same ones presented to co-counsel, and they were available Friday. But the Fusion Center has downloaded everything but one cell phone that they could not open. It's not the state's fault that the defendant has in her possession a phone that they want to get into. We don't have that evidence. I don't know if that phone can be opened or not. The Fusion Center could not open one of the cell phones that they were presented to and asked to download. But those guys really, really came through and did a great job. They put all the resources that they had available into that. And at the end of the day, the defense had essentially been provided with all of that information. A lot of this is just duplicates. We would like to have the opportunity to have the state and the investigator compare this stuff to see exactly what we're talking about. It may be zero, it may be a lot. We just can't answer that at the moment.
Mr. Sullivan said it would take a minimum of a week to do that. Do you believe that is a fair assessment?
I'm not so sure that's true. I think a lot of it is a matter of comparing the way that when you open these external hard drives, it almost shows up like an index, and if A meets B, those are the same things. And then it's up to the other side to look at it and see what's in there. The vast majority of the discovery that's been provided really is not all that highly relevant. And I mean, there's one of the things that the Fusion Center did, just by way of example, was they unloaded hours of surveillance tape. Okay? That's not helpful in this case. It doesn't show anything. But it was provided. And so in terms of, we won't be able to intelligently discuss how long it would take to review this until we know exactly what it is that has to be reviewed. I suggest to the court that by the end of the day, we report to the court a status of how that's going. And if we need to conduct other hearings, or maybe the parties can agree that it's just not possible to go forward given the volume of information that was erroneously not provided, or it may be that we can go forward.
All right, let's see what develops and allow that assessment to occur, and then the court will be in a better position to make a decision. Yes, Mr. Sullivan.
Our investigator whispered to me that because of the complexity, he said it might even take up to a month. And we're talking about comparing what we have and what we do not have, and then we have to go through it. Just seeing what we have and what we don't have is fine, but then we have to go through all that information, select exhibits, pull out what we think is relevant to the trial. That takes a lot of time, Your Honor.
Could the state respond briefly to that?
Sure.
The fact of the matter is, the defense has had a lot of this stuff for a very long time. So we're only talking about comparison to what they have, when they had it. And if that's the case, that may not take months. That may take hours, days, because in theory, they've been preparing for this all along, just as the state has. So we don't know the answer to that.
There are a lot of unknowns that we have to nail this down before we can make a value determination. This is the court's observations. This is a difficult case. It involves massive discovery, but it's been pending for over a year. And there was the other case that was pending for a long period of time, and Mr. Victor was involved in that. Every hearing that I've held in the case assigned to me, I've heard the same complaints. Complaints about discovery, complaints about not being able to open hard drives and open phones. I was assured by the prosecuting attorney, Mr. Hatfield, that all the discovery had been provided to the defense. And it's somewhat irritating and certainly disappointing to find out now that it hasn't been. I can't lay this certainly at Mr. Truman's door, because Mr. Truman has only been involved in this matter for a matter of weeks. But the prosecuting attorney's office assured me over and over at every hearing that all the materials of discovery were handed over to the defense. I'm of the belief that if we continued this case for 2 years, we'd still be back here right before trial, arguing over discovery and dealing with complaints from the defense that they're not ready for trial. We have to go forward. This case has been pending too long. It needs to be resolved for everybody involved in it. I'm going to deny the motion to dismiss. There's no nefarious behavior on the part of the prosecuting attorney's office to substantiate such a motion. I'll preserve the defendant's exception in that regard. I'll hold the motion to continue in abeyance, and we will see what the investigator can determine with Ms. Acord. We'll see where we are, and we will likely have to have an additional hearing or two to sort things out. But frankly, I'm of the belief that we can go forward as scheduled. We have the jury coming in on the 21st and the 22nd, or is it, I'm sorry, it's the 22nd and the 23rd. for jury selection. I think we can go forward in that regard and at least get our jury selected, and we can go forward. If we have to adjust the trial date a little bit, the court will see what we can do in that regard.
Your Honor,
Yes.
could I have a definitive ruling on my motion to compel as to the things listed?
Your Honor, the state has not yet responded to the motion to compel.
All right, I'll have to give the state an opportunity to respond.
They have responded, Your Honor.
All right.
Your Honor,
State's
we've not been able to
responsibility.
present argument as Mr. Selden was able to do today.
Well, let me see if there is any objection to the matters that are requested in the defendant's motion to compel discovery. It seems to me that all this stuff has been turned over. We're dealing with slides. I understand that the slides cannot simply be handed over to defense counsel, but they would have to be delivered in a protective manner of procedure to the defense expert. And we must live with that, we must deal with that. It just seems that the rest of the material set forth in Mr. Selden's motion have either been provided or perhaps turned over this morning.
Your Honor, I would like the prosecution to give a definitive answer as to whether any of these things exist or are available.
Okay, do you want to go through them line item by line item, Ms. Acorn?
Your Honor, I will do my best to do that. The photographs that have been requested by defense counsel with regard to the exhumation of Michael Cochran were presented not only on July 11th of 2024, but also on March 4th of 2024. They have received those items twice, and we do have certificates of service within our system to prove that they were sent to defense counsel. As Mr. Selden stated, in my review of each of the reports, the bag of organs that was recovered from Mr. Cochran's body when he was exhumed was reinterred with him. So those are not available for the state to provide unless he is exhumed a third time. Your Honor, I did review Dr. Kubitschek's report, which was provided to defense counsel on February 1st of 2022. He took several tissue samples and blood samples at that time that were put through multiple toxicology reports. I did review the report from NMS Labs, which was within Dr. Kubitschek's report that was provided to defense counsel. And in that report, it states that unless alternate arrangements were made, which to my knowledge they were not, the remaining submitted specimens would be discarded 6 weeks from the date of that report. So upon information and belief, those specimens are also not available to provide to any experts, which have yet to be disclosed. Oh, yes, and I'm sorry. Also, with regard to the microscopic slides that Dr. Uribe obtained, he advised us that those materials were so badly decomposed that he did not even feel it was worth it for him to put them through any testing. It is our understanding that he does still have those slides, but even he did not feel that they were worth testing because of the decomposition of Mr. Cochran's body at that time. But he would be happy to provide them to the expert once the expert is named.
All right.
I have nothing further to address, Your Honor, unless there's something else the defendant would like to
I'm prepared to grant the defendant's motion to compel discovery with the understanding that Dr. Uribe's slides referenced by Ms. Acord, the 6 slides of tissue retained for microscopic examination shall be provided only to the defense expert, not to defense counsel under a procedure worked out by agreement or specified by the court.
Thank you.
All right, are there any matters from the defense?
Your Honor, that would require, I need to object to that in that since we haven't actually secured our experts, we have potential experts, we would have to divulge potential experts, which we may or may not have at trial.
Well, how do you propose to do this? Just hand the slides over to you? I mean, we have to be concerned about the chain of custody. If we do that, that would give rise to an objection in that concern. I'm open to any type of procedure to get these slides to your expert, but we have to be mindful of proper process.
Sealing those records and sending them directly or through a third party, through either the court to disclose those records to the court and have the court provide them to the potential expert, whose names, of course, the court knows and whose record is under seal.
All right, with that process suggested, be agreeable to the state. They would be sealed, delivered to the court, and then the court could make appropriate arrangements to deliver them to the defense expert.
Your Honor, why should we involve the court in that?
Well,
if they name an expert, Dr. Uribe said he would be glad to get rid of them because they're useless, but they're entitled to them. That's fine. But that shouldn't involve anything other than a simple, here's our expert, here's his address, here's his contact information. Dr. Uribe will call him, they can arrange to exchange them any way they like. This is not that complicated.
We're faced with that. I'll do whatever I can, but it seems to me to expedite the process, Dr. Uribe should send the slides directly to the defense expert. At some point, you're going to have to disclose who your experts are, and so it might as well be up front.
Your Honor, there is still a motion to suppress the bottle pending, but I think that it would be probably better to take it up at a later time once we have checked all the technological discovery in this case.
All right, that sounds like a plan. Thank you all very much. This hearing has been concluded.
Thank you.
Some questions. Second line by something, you have to spend 15 months for these compassion.
Yeah.
Yes, I'm going to spend 2 days.